Next up on This Week in Law, we're joined by Professor David Levine from Elon University, and he is going to shed some light on some things you need to know about that haven't been discussed much in the media. We're going to talk about the TPP. We're going to talk about trade secret protections perhaps being overbroad. And we're going to discuss President Obama's executive order related to cybersecurity and how it impacts CISPA next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 198, recorded February 15, 2013. Fracking Transparency. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow, send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter Twill. And by LegalZoom. LegalZoom is not a law firm, but provides self-help services at your direction, such as affordable business and personal documents you can trust. Visit LegalZoom.com and use offer code TWILL to receive $10 off at checkout. Hi, folks. This is Denise Howell, and you're joining us for This Week in Law. I'm really excited that you're here today because we've got a wonderful guest, David Levine from Elon University School of Law. Hello, David.
Hello. Thanks for having me.
It's great to have you. David also is the host of one of my favorite law and technology podcasts, which is called Hearsay Culture. So it's great to finally have you on our show.
Same here, and I'll make the public invitation to have you on Hearsay Culture sometime soon.
Sure, would love that. Also joining us is Evan Brown from Chicago, Illinois. Hello, Evan.
Hi, Denise. Great to talk to you on a Friday as usual. And David, it's very nice to meet you. Really been looking forward to our conversation and having a great time today.
Same here.
Right on.
Me too. Well, there's been lots going on. We had the State of the Union on Tuesday, and various things that President Obama and Congress have been up to lead me to think it would be good to start out with some privacy stories. All right, so in the State of the Union, tech and tech policy were very front and center. A lot of talk about cybersecurity and what the administration would like to do about it. In fact, President Obama has issued an executive order on the topic. And for folks who scrutinize such things as proposed privacy legislation and privacy-related or cybersecurity-related executive orders, the reviews seem to be 2 thumbs up for what President Obama has proposed. Evan, can you give us a little bit more detail?
Well, sure. The executive order does, it goes in this direction of cybersecurity, which is an issue that is of growing importance. And we see real life examples of that with hackers in China and other parts of the country, and even some, plenty of domestic activity gaining unauthorized access to systems. And the risk is that these hackers will gain access to what we refer to as critical infrastructure, the power grid, our banking system, our major communications networks. And so last year, up through the fall, we were talking about CISPA, some legislation that actually did pass the House that strengthened the framework for cybersecurity. And the big thing with CISPA was information sharing about cyber threats between the private sector and government. Intelligence coming from the government to the private sector and information about specific threats going to the government. But even though that passed the House, and probably fortunately, on balance, it did not pass the Senate. There were plenty of issues in CISPA that got people's privacy hackles up, about this information sharing with the government. What's going on there? So Congress did nothing on that. Like I say, probably fortunately. So President Obama, recognizing both the political stuff to be gained from doing something on cybersecurity because of its importance, and also, truly to meet this interest here, has been floating around a draft of an executive order to do whatever he can to strengthen the agencies abilities to respond to cyber threats. So what we see in this executive order is it's largely the content of this executive order that he issued on late in the day on Tuesday, right before the State of the Union address, and people started analyzing by the time Wednesday came around. It strengthens the framework for the Department of Homeland Security and the Attorney General for them to do things to be better at gathering information and disseminating information about cyber threat intelligence and information to the private sector. The reason it's getting a thumbs up is probably from privacy advocates and civil liberties organizations like the ACLU, is that it does not contain some of the problematic language from CISPA that allows the private sector to, with immunity, share information about cyber threats with the government. The risk is that, the private sector runs slipshod, for example, over the Stored Communications Act if a statute comes along and gives it immunity for sharing information with the government. The executive order does not do that. And so we've got to applaud it for that reason, but we've also got to keep that in perspective a little bit because, after all, it's an executive order. And yes, it does have the effect of law. It does have the force of law, but the president can only do so much. He can't, add new immunities under the law. That's something only the legislative branch can do. The best that the president can do, and indeed what I think he does do, is kind of, tighten things up and make things more tidy and more efficient with the agencies for preparing for, gathering information, and indeed responding to cyber threats in this space. So that's why it's on balance. It's a good thing. It's an okay thing that this executive order came out. We shouldn't be too concerned about our civil liberties in this.
Right. And the president seems to have then looked to Congress to do something more proactive about the concerns that he has raised and in the way that he has steered them. It seems to me, although we have had CISPA reintroduced now with all of its former baggage coming along with it, that's not what the president has in mind. David, do you think CISPA will languish while Congress now has to get to work on something more in line with a privacy respectful cybersecurity approach?
Yeah, so that's a good question. I mean, it seems clear, and Mike Mazik at TechDirt had wrote this in reading through, and I tend to agree with him that, given that the president's order is much more respectful of privacy and other concerns, for that matter, that people had with regard to CISPA, that perhaps the best move is to let the order play out and see what, if anything, is needed in addition. Having said that, though, Congress's general ability to control itself when it comes to regulation in these areas tends to be quite limited. And so I would be surprised, particularly as some of the exposure issues with regard to data sharing aren't hashed out if you don't see versions of CISPA or alterations, if not a full-blown CISPA, put out there. I'll also note as an aside and a general concern of mine when it comes to any of these discussions is what amounts to quasi-public and public-private partnerships. Whenever you have data sharing going on between government and the private sector, it's not only a question of privacy, but it's also literally a question of what rules are in place for data sharing and what can the data be used to do. And so without having very clear delineation of those metes and bounds, a separate concern is the relationship of government and private sector, which leads to a much broader question, which is literally what is the role of government as more and more outsourcing and partnership occurs with the private sector.
David, what the heck is a fusion center?
Yeah, so this is interesting. Over the last, I don't know, at this point, I want to say 5 years or so, there have been discussions regarding these entities known as fusion centers, and what they are entities created by state and or local law enforcement entities under the guidance of the Department of Justice, designed to do a variety of data mining type efforts. Now, in the traditional and narrowest sense, and perhaps least controversial sense, these fusion centers, which are not required to be formed, but can be formed by a state or local government, are designed to go directly after terrorism-related threats. threats. And so, the fusion center idea in large measure was born out of the experience both prior to September 11th and then the investigations afterwards, where there were, pretty clear failures of not only intelligence but also of information sharing. And so the goal, which is broadly speaking laudable, is to allow for more coordination between the private and public sector in going after serious national security threats and largely non-controversial ones. And while the fusion centers do generally work with data which is publicly available, they leave open partnership type scenarios where the government and the private sector can work together to pool information and therefore go after threats. One of the concerns that's been raised, and it was raised heavily by the ACLU in a report a few years ago, was the question of where exactly the lines are. In other words, what prevents a fusion center from going from the question of literally terrorism to something else. And on a personal level, my concern, not being an expert in law enforcement per se, but rather more concerned about public-private partnerships generally, is again what the rules are associated with sharing that data, and even more significantly, what the public will know or can know about that sharing. And so to the extent that these entities operate outside the ambit of freedom of information laws and sunshine laws, I get very nervous.
And you're saying they do operate outside the ambit of those laws?
Well, it is literally often a state-by-state analysis. So they're to the extent that we have fusion centers, and by the way, some of these fusion centers you can find out about online, others you can't. Some have listed phone numbers, some don't. States have clearly within their abilities as state governments to pass laws that exempt these entities from freedom of information laws. And so some states have actually done that, where they've said any request for information regarding a fusion center, generally speaking, is not subject to our state's freedom of information laws. And again, to the extent that these kinds of information sharing practices are occurring, my view is, and this is my view, and it's one that is subject to debate, the public should have a general right to know at least the rules and the behaviors and the protocols, if not the actual information, which of course would perhaps raise privacy concerns, among others.
Well, David, couldn't that actually go two ways? Because I know CISPA, despite all of its imperfections, and they are numerous, one of the things that CISPA does do, or will do if it's enacted, is to carve out an exception for availability of information that is turned over to the government under the Freedom of Information Act. It actually does refer to FOIA and says whatever information the participants in the private sector turn over to the government here is not subject to disclosure under FOIA. And people look at that as a good thing generally, or at least a not bad thing. How is that different than what we're talking about here and the concerns you're raising? Because what I hear you saying is that, oh, that's terrible because we're left in the dark because we can't get at this stuff with FOIA. Well, I wouldn't want information about me, for example, that's in a fusion center to be available under FOIA because I don't want it to be available.
Right, and Evan, that's a great point. And to be clear, my concern is not broadly that all information regarding fusion centers, or to be clear, all information shared with the government. Let's take it at a broader level, should be public. The way that the Federal Freedom of Information Act operates, and every state freedom of information law I'm aware of operates, is that the government starts with a presumption of openness unless an exemption from that openness is met. And my concern is twofold. First, literally, and this is fairly, I admit, fairly arcane administrative law, but in our society, I think it's incredibly important, and also does still need a lot of work. The question of what exemptions are used and whether we're using literally the right exemption for the analysis of whether something should be made public is one concern of mine. And so I know I sound like I'm talking from a theoretical perspective, and I guess as a law professor I reserve that right, but this has very practical implications. So, and we can get into it later if you want with regard to trade secrecy, but the broad question is this: I want to be sure that when, and my broad concern with regard to CISPA is this, I want to be sure that when, and remember, it will be an administrative entity, does the analysis as to whether the information is going to be made public, that it is weighing the public concerns and the private concerns appropriately. And that decision and that weighing, assuming there is weighing, will in large measure be dictated by which exemptions are used. So for example, if we're going with a personal identifying information exemption versus a national security exemption with regard to access information, the outcome could be very different. And so again, and it really is too early, of course, to prognosticate as to what would be used, but without question, that thinking needs to happen. And again, I don't want to get too far ahead of other topics, but for now, I'll simply say that national security as an exemption to freedom of information laws is often used in areas that are not traditionally, at least we think, national security issues.
Got it. Well, I appreciate you raising the issue. It's not a concern that I have seen a whole lot written about, and it just doesn't seem to be on too many people's radar. So it's good to know that it's out there and it's something to keep an eye on. And in fact, just to keep it on people's minds, let's make Fusion our first MCLE passphrase for this episode of This Week in Law. And I want to get into talking about those trade secret concerns, David, in just a moment. But first, we're going to thank our first sponsor for this episode of This Week in Law, which is ShareFile. You know, in business, we need effective communication. It's absolutely the only way that you can get things done. But sending email with attachments that are too big, that bounce back, that wastes your time and energy and really upsets and annoys your clients and customers. Dropping your files into online boxes for others to access is not safe or secure. So that's why we're talking here about ShareFile by Citrix. ShareFile understood these challenges and created a better solution for your business. Now, millions of accountants, lawyers, and other business professionals rely on ShareFile. ShareFile is so easy for anyone to use. It allows you to send files of almost any size securely. You can track the progress of your files. Notifications are automatically sent when files are opened. You can control who has access by using tools like password protection, and you can even sign and edit files for streamlined collaboration. Plus, with ShareFile, you can access files from anywhere, your laptop, tablet, or smartphone, so it functions both as a remote access kind of platform and also as a way to make sure that those documents that you need your clients and customers to see get seen. So I have a special offer for you from ShareFile. You can try it for free. You sign up for a 30-day free trial. You don't need a credit card. You don't have anything to lose. You do that by going to sharefile.com and clicking on the microphone there. Enter in the word TWIL, T-W-I-L. That's sharefile.com and type in TWIL. Thank you so much, ShareFile, for your support of This Week in Law. All right, since we're talking about things that are secret and what things should remain secret, let's talk about trade secrets. Obviously, businesses like to keep their secret sauce under wraps as much as possible, but there are a couple of areas that you raised for us, David, as we were getting ready for the show today, where businesses may be overreaching in their invocation of trade secret protections. Let's talk first about the Google algorithm. Why shouldn't Google be able to keep that under wraps?
So this is a really interesting issue, and it's one that some scholars have given attention to. Perhaps most notably Frank Pasquale at Seton Hall. But the idea is this, right? Broadly speaking, the search algorithm that Google uses, of course, is the gateway for most people at this point to the internet. If you're seeking information, you're not typing a domain name into an address bar. You're Googling it, and so that situation, right, raises and puts primacy on rankings. And of course, I don't need to, talk about rankings here and what they mean for you or this audience. So the question is this, right? Google's business model, of course, turns on the algorithm, right? The algorithm has to have, has to at least be perceived as free from bias. It has to appear to be organic, right? So when you have those sponsored links, Google makes sure to indicate that those links are in fact paid for so that they're not part of, what people call the organic results. But of course, how Google ranks those results, right? What results actually appear on the first page is algorithmic and is based on an algorithm that Google treats as a trade secret. In other words, it's not something that is publicly accessible. And the definition of a trade secret, generally speaking, is information that is valuable because it is not generally known. And so Google's search model is literally that our algorithm is proprietary. Our algorithm is literally ours. We use it to rank results. We deliver those results to you based upon your query using algorithmic analyses that are not for you to have, because for you to have them would allow you to build something like Google and compete, and therefore it is valuable because it's not generally known. The issue with regard to trade secrecy is an interesting one because to be clear, Google's right. I mean, as far as trade secret law goes and how it's generally interpreted, and we can get into the weeds on that too if you'd like, right? This is a trade secret, and it's not a terribly controversial one. And my concern, again, and my concerns do often turn on these issues of secrecy and transparency, and it's something I spent a lot of time on both in writing and in advocacy, is whether the public should have a right to know a bit more about those search results, how they come about, right? What actual decisions are being made, because Google's ability to control, in that sense, access to information is one that is perhaps of greater concern to us than merely Google's. In other words, it turns the corner into something that is not just your traditional trade secret. And even though some people deride it, I still use Coca-Cola or the formula for Coca-Cola as a classic example of a trade secret because it pretty much is, right? Google's search algorithm is so important now on issues of access to information that perhaps we should rethink whether trade secrecy and its ironclad ability to keep information from the public should keep it a secret.
All right. Well, I can definitely understand why there would be a huge desire in the marketplace and perhaps on the part of the public to have access to that kind of information. But Evan, do you think it's a good idea?
It's a tough issue. And the way I like thinking about this, or at least characterizing the Google algorithm trade secret issue, is comparing it, seeing that it's very closely related to the antitrust concerns that people have about Google. Because clearly Google has its interest as a private actor in maintaining the secrecy of its intellectual property. Let's not forget that trade secrets fall under, the umbrella of those things which are protected as a form of intellectual property, whereas we also have the public interest that's served in being able to find out all of this stuff. So I guess I'm a little bit disturbed when if the analysis goes that we should somehow punish Google for having developed a really good and successful product that everyone wants to use. That's kind of the antitrust argument against Google, saying, well, they're just successful and everybody happens to use it. They have this huge market share. Why should that, serve as a penalty? But at the same time, there truly is a public interest that's served, and there's good analogy making that goes on when we think about how the Google algorithm, which incidentally, as we've learned, is constantly changing, almost literally twice a day. The analogy, there's good analogy making to be had, comparing that with the formula for Coca-Cola. But at the same time, you make arguments that the protection for the Coca-Cola formula is not unlimited, because after all, if the government suspected that there was something toxic or something unfair, or unfair is not the right word, something in the formula for Coca-Cola that shouldn't be there, then it wouldn't be on the marketplace. So at least we know certain things are not untoward with that. Shouldn't there be something analogous to the way that we know that the Google algorithm works, so that there's not something in it that makes it unfair and otherwise not fully in service of the public interest? It kind of breaks down, gets into too much of an abstract or nebulous concept here. But we've got to just look at the different comparisons that have to be made. On one hand, the private interests that Google has versus the public interest that we have in making sure that business is conducted in a way that's appropriate within a free market economy like this.
And that's I'm sorry, Denise, go ahead. Yeah.
I was just going to say, well, David, I have to thank you for bringing to our attention the fact that there is a practice out there in the world that goes by the name of fracking, and people do, discuss this with a straight face. And it's having read this now, which I had not heard of it before. It is a way of basically strip mining for natural gas. Do I have that right? It's a way of using liquid. It's hydraulic fracturing is the term. Using a liquid blasting process to free up natural gas. And there are health and safety and obviously environmental concerns involved in that. So it's easier to see why there would be a strong public safety interest in getting at how this is being done so that people can address whether it's a health issue or not. Is there a parallel kind of concern when we're talking about Google or no?
Yeah, so that's a great question too, Denise. To be clear, and I've written quite a bit on this issue, and so I do want to offer this by way of a general view. I am not opposed, and I hear this. I'm not opposed to trade secrets. In fact, I am a fan of them. I think that they serve a useful purpose in many settings. The problem is, and I'm getting to an answer, by the way. The problem is that trade secrecy is now used so broadly, and the definition of what is a trade secret is so broad that there's a lot of information out there which is, again, under the law, designated a trade secret, meaning that the owners of that intellectual property, and I agree with Evan there as well, of that intellectual property have the ability to sue others for accessing it, and that access may be illegal, or that access may be you accessed it, and that's where the concern comes up. The concern comes up often, and this gets to fracking, that trade secrecy can be used as a way, again, and here's freedom of information laws coming up again, as an exemption to freedom of information. And traditionally, when we thought about trade secrets as exempt from disclosure, they generally have come up in the context of a disclosure made by a regulated industry, like, for example, the energy industry, to a federal or state entity, for purposes of regulation, right? The state or federal entity has a need to access this information to meet the regulatory mandate. And so naturally, we would say that the public shouldn't be able to then grab that information from the government when the trade secret holder merely shared it for regulatory purposes. I don't have a problem with that broadly. But the issue becomes, and the problem is, that trade secrecy, in my view, was not designed to address scenarios where the trade secret is not the formula for Coca-Cola, but, for example, the formula for the liquids and chemicals used to do fracking, where that formula, depending on what the chemicals are, may have geological impacts, may have environmental impacts, may have other impacts, may have health impacts. And I am not an expert on either the energy industry or on environmental law per se, but I am very concerned, again, when trade secrecy is used in a carte blanche way to say, look, our trade secrets and our competitive advantage concerns are more important than the public's interest in finding out whether, in fact, what we are doing will create and, name your potential environmental harm. And to be clear, fracking may not be harmful, but in the absence of public information, trade secrecy becomes a barrier, in my view, to not only the government's ability to regulate these industries, but more broadly, the public's ability to have confidence not only in these industries themselves, but in the fact that their world is safe. And so is there an analogy? Yes. Could we debate, of course, whether environmental harms are greater than, let's say, informational harms or search harms? Sure, we could. But yes, the analogy is there, and it goes further. When you deal with things like voting machines, where the source code of voting machines is a trade secret. Am I concerned particularly that there's a secret plan on the part of voting machine companies to control elections? No, I consider those concerns to be fanciful. Am I concerned, again, that the public should have access to source code in order to determine whether, in fact, their voting machines are working properly? Yes. What stands in the way of that? Trade secrecy. So there are these parallels that run through.
What about copyright standing in the way of it as well?
Well, so copyright is you're talking about with regard to source code. Yeah, I mean, so copyright is an issue, but that is more an issue of ownership of the information and who can use it. right? Trade secrecy, which to be clear, is also a concern. But trade secrecy literally deals with whether you're going to have access to the information in the first place, right? Copyright law does not prevent your access to information, right? Copyright law prevents your use of that information, right? It protects the expressions. When we talk about trade secrecy, by definition, we're talking about information that is a secret, and that there are reasonable efforts to maintain the secret. So in other words, in order for you to access that information, you'd either have to use one of the few lawful ways to access a trade secret. And what are they? Well, the main one is reverse engineering. So to the extent that you can access a trade secret by disassembling it or taking it apart, trade secret law says that's fine. Right? But that may be impossible, or it may be extremely difficult or cost prohibitive. The point is the public or the government may not have the ability to do it. So copyright law does stand in the way of access to information from a use standpoint. But trade secrecy is literally a wall against accessing the information and even knowing, to be clear, that it exists. And if we don't even know whether the information exists, and we're using a law designed to deal with misappropriation of commercial secrets, we've got, in my view, an enormous disconnect, and one of increasing importance.
Denise, if there's anything in the copyright context that would kind of go along with the concerns you were raising by your question just then, it would be with DRM, wouldn't it? And the anti-circumvention provisions that we were talking about last week, and their ability to, as David's saying, affect your ability to lawfully access something. Don't you
so let's take this to its logical conclusion, David. Suppose that we get government on board, and I suppose you would have to get lawmakers on board with the fact that that trade secret law is being too broadly applied and is acting against the public interest. How would that play out? How would you force Google or a hydraulic fracturing enterprise to disclose these secrets?
So of course, and that's the huge policy question, right? So if you're willing to accept that trade secrecy isn't the right rubric, then what do we do? So I guess I have a twofold response there. That is a hard question because, again, the major pushback on all of this would be, and it's not an implausible argument, and it's not one that lacks merit generally, would be, look, if you force us to reveal our trade secrets, then we're not going to enter this market, right? We're not going to make voting machines. We're not going to engage in this industry. I really have three responses to it. First is I would want, and this sounds like law professor stuff, but it really does have practical impact. I want legislators to recognize that trade secrecy is not the rubric through which to do this kind of analysis. In other words, if we have concerns like that, there are other exemptions and other ways to do that analysis. I would like, for example, legislatures to focus more on the question of literally the public's right to know, which again is not part of a trade secret analysis, than merely competitive advantage. I would want legislatures to put an increasing premium on the question of whether there are in fact competitors to an entity claiming a trade secret. To blow your mind even further, governments, at least at the state level, can claim that they have trade secrets. So the government can say that it is a market actor, and under state law, to be clear, and under some state laws, many state laws, but not federal law. But under state law, a government can say that they are exempt from disclosure of information because they are holding trade secrets that they themselves own. Okay, so we're now engrafting commercial law principles on governments that traditionally have transparency concerns. So step one would be to recognize that trade secrecy may not be the right rubric, and in fact, I'm arguing isn't the right rubric through which to do this analysis. Step two would be, and in terms of legislatures, I would want legislatures to require that when a given industry designates something a trade secret, that there is significant scrutiny of whether, in fact, the trade secret exists. And in other words, is it in fact true that the information that the entity is submitting to the government in that instance is a trade secret? Are they going to kick the tires? Generally speaking, the law doesn't create much of an incentive anywhere for a government to strictly scrutinize whether, in fact, they are holding trade secrets. In other words, whether the corporation claiming a trade secret is right. And so I would want to both increase the duty on the government to do that work, but also make it less risky. In other words, the incentives are clearly to say, look, you say it's a trade secret because there are stiff penalties if, in fact, that trade secret is revealed when it was designated as one. So you'd have to rebalance that. Thirdly, I'd want to consider seriously the notion of public escrows, right? The idea that, okay, fine, you have a trade secret, right, entity. You have the ability at least to share this information with other entities, whether they be the government, right? And sometimes the government has not reserved that right. Other times it could literally be watchdog groups. And I know this may sound like pie in the sky, but creating a mechanism whereby there could be intelligent discussion among interested parties about a given trade secret from a regulatory standpoint beyond the government itself, right? So a environmental watchdog, for example, I don't think is implausible. Lastly, right, and this is certainly the most controversial, there may be particular areas or types of information that should not be trade secrets. And so you'd have to do an industry by industry analysis and say, to be clear, if you want protection for that information, you're going to have to go another route. Patents, for example, right, by definition, require publication. You cannot have a secret. You can have a secret patent in the sense that there is secret prior art, and I'm not going to go that deep into patent law, but suffice to say, you can maintain some secrets. But once you get a patent, it's public, right? And that information is public. So to the extent that we're going to say, for example, to a voting machine company, you are creating something which is a public infrastructure, right? And the privilege of creating voting machines requires you to forego some protections. And one of those protections is going to be trade secrets. You can still have a patent, right? And I don't really have a problem with patents in this regard. You can have a patent, or even, and let me be real controversial, I don't have as much of a concern about copyright necessarily, although I do have concerns. You have to go that route. You forego your ability to maintain commercial secrets because the information that you hold is of such a national public priority that you're going to have to give up something to serve this unique market. And let me say, practically speaking, I'm not convinced that a voting machine vendor wouldn't say, fine, that's the deal, that's what I'll do. Because how many governments or how many people are going to need voting machines? So that's a long answer, but that's kind of where I'd like to see legislatures going.
Got it. Well, I'm so glad that you brought this up. It's very important and interesting to think about. And I want to get into more trade-related discussion with Professor David Levine in just a moment here. But first, I'd like to thank our second sponsor for this episode of This Week in Law, and that is LegalZoom. Now, I've been getting a lot of emails and communications from people who are questioning our having LegalZoom as a sponsor on This Week in Law and wondering whether by having this sponsor, we're encouraging people not to seek out lawyers. And no, that's absolutely not the case. And that's not what LegalZoom is all about either. I would encourage you to think about LegalZoom as a way to save money on your legal services. And for that, it is a fantastic service, both on the personal front and the business front. In fact, if you've been waiting for the perfect time to start your dream business, it's right now, because you can incorporate your business or form an LLC at LegalZoom starting at just $99. Now, you might not want to do all of this yourself. Of course, LegalZoom is a way for you to represent yourself if you choose not to consult with a lawyer in the process. You might want to consult with a lawyer in the process, whether your own or LegalZoom has an extensive network of plan attorneys that you can consult with to make sure that when you fill out this form, you have done everything that you properly need to do to form your business the right way. You're going to save money on taxes when you do that. You're going to ensure your personal assets are legally protected. It can also help with trademarks, copyrights, patents, NDAs, and more. And if you have a family, guess what? You need to make sure they're protected too. You can protect your family and assets with a LegalZoom will for just $69 or establish a living trust. If you don't have a will, you leave it up to the government and courts to decide what happens with your family and assets. So in the past 12 years, only over 2 million Americans have used LegalZoom for LLCs, wills, trusts, trademarks, and more. Its online process guides you step by step, so it's easy to use, and you get total customer support. If you have questions or need advice, and this is where I think it's really important that you know, they always say that the most foolish lawyer has himself as a client. And I think, you know, that goes for people too. You don't necessarily want to do everything yourself on when you're dealing with your important legal rights and protecting your business and your personal assets. So what you want to do is either consult with a lawyer on your own, or you can access the network of attorneys that LegalZoom's legal plans make available in most states. And that is a very reasonably priced way for you to make sure that what you're doing is the right thing to do. You can search their online profiles and unedited customer reviews to work with a LegalZoom plan attorney that's right for you and your business. So start your business and protect your family today at LegalZoom.com. LegalZoom is not a law firm. You can get self-help services at your specific direction, or you can speak to a legal plan attorney to get your questions answered and get ongoing advice. To receive a special offer, a special thank you offer for using LegalZoom through Twit, make sure you enter the offer code TWIL, T-W-I-L, in the referral box at checkout to receive $10 off. So go to LegalZoom and use the offer code TWIL. Thank you so much, LegalZoom, for your support of This Week in Law. So, David, another thing that we're not hearing much about out there that is very important, now this is on the legislation and policy front, so why don't we take a moment here and shift our mindset over to those kinds of issues. We have the TPP free trade agreement floating around out there. Talk about secrecy. It has not been very well ventilated, or the ability to scrutinize it has been very limited. What is its status, and do you still have the kinds of concerns that you had when you wrote about this extensively last year?
So the short answer, Denise, is it's still being negotiated, and yes. But getting into more detail, the TPP is the Trans-Pacific Partnership Agreement. It is it's a multilateral negotiation occurring between the United States and about 10 other countries, countries like now Mexico, Chile, Australia. And several others. And you can find out actually who's negotiating at the U.S. Trade Representative's website. The U.S. Trade Representative is the office representing the United States in these negotiations. The Trans-Pacific Partnership Agreement has been generally described by the Obama administration as a 21st century agreement designed to address a broad array of trade issues among the signatory nations, ranging from traditional trade topics like the trade of tobacco to very untraditional trade topics like regulation of intellectual property and the internet. If I remember correctly, I think it's the 16th round of negotiations is occurring next month in March in Singapore, again, one of the negotiating countries. And it is an agreement which among the 20 plus chapters includes a chapter which is designed to harmonize law amongst the negotiating countries involving intellectual property. So it can include provisions dealing with copyright infringement and cross-border enforcement, agreements among countries as to how to not only define what copyright infringement is, but how do you enforce those arrangements. It ranges on issues of patents and a variety of other issues. Here's the key thing. We don't know, as we sit here today, what exactly is in the negotiating text. In other words, we have not received, and this is now 16 rounds of negotiations going over several years, we as members of the public do not have access to the actual texts that are being negotiated. And so the issue again, and I find it amusing on a personal level that my interest, in intellectual property and internet regulation, so much of it now turns on what amount to really policy on the administrative law level, because again, we have an issue of secrecy. What is happening is we don't have access to these texts, and the result is that the public does not know what those negotiations are. However, because this is being negotiated through the U.S. Trade Representative, there are panels of advisors to the USTR who do have access to these texts. And the panel involved in intellectual property, which is really my concern, is a panel made up almost exclusively of representatives from the entertainment and pharmaceutical industries, or the content and pharmaceutical industries, I should be more specific. And so they have preferred access to this information, and their counterparts, if you will, in the civil society world, the Electronic Frontier Foundation, Public Citizens, et cetera, of the world, do not have that access. The result is you have a disparity in input. And so my concern is a failure on the part of, in this case, it is the U.S. Trade Representative, to seek open input by giving the public a level playing field. To be fair, this is also a controversial issue because the U.S. Trade Representative would say we cannot negotiate an international agreement if we're going to be under the constant scrutiny of the public seeing the text. I'm not convinced of that at all. And I've spoken at several rounds of TPP, the last 3 rounds. I'm not planning on going to Singapore to raise this concern.
All right. Well, we're going to make TPP our second MCLE passphrase for this episode of This Week in Law. You can head on over to our show wiki for more information about getting MCLE credit for listening to the show if you're in the legal profession or if you're in other professions as well. David, I asked you before, so what do we do? I guess in this case, what we do about the TPP's lack of transparency is just make a lot of noise with the U.S. Trade Representative?
Well, that seems to be the case. I mean, to be clear about this, TPP, if enacted, could result in an anti-counterfeiting trade agreement and even SOPA and PIPA-like rules coming out of international agreements and then literally requiring countries to go down that path. The key point is we don't know. And after 16 rounds of negotiations, my view is it's time to seek broader public input. The best way to impact this is literally, and this is, why, Denise and Evan, I'm thrilled you're covering this, is simply educating the public that this is happening. Because most people, even people that are focusing broadly on IP and internet policy, are not necessarily aware that this is going on. So yes, it is literally that. Now credit, has to be given to groups like EFF and Knowledge Ecology International and Public Citizen and Consumers International and others who have been working tirelessly on this. Mike Geist in Canada has done terrific work. Sean Flynn and Mike Palmetto, an American, and there are others. And so there are certain entities and organizations who are there attempting to be a counterpoint. But as generally speaking, right, the public really doesn't know what's happening. Emailing and contacting the U.S. Trade Representative and seeking text would be helpful. Interestingly, Representative Issa and Senator Wyden in Congress have both been very active in trying to push the U.S. Trade Representative to be more transparent on these issues. I've been involved in efforts on, writing letters and other types of documents on behalf of law professors who sign on regarding this issue. But the bottom line is this: I'm interested in broad public input. I want to see balanced law. I don't want to see these laws captured by, to be clear, either entirely consumer or public-oriented groups or entirely content industry and farmer groups. I think we can have a reasonable balance that achieves the dual goals of fighting legitimate infringement and copyright infringement or patent infringement, which is happening, while not destroying technology, creating situations where people can be sued without notice and claims brought against them that literally lack merit because fair use, for example, the defense and copyright is not in the law, as may be the case with TPP, and seek balance. And I think we can only get balance through broad public input, and that's not happening right now. And so I consider it a failure on the part of, sadly, my own government in not pushing a democratic lawmaking process that by the way, makes Congress look like the epitome of perfect government.
All right. Well, thank you so much for shedding some light. This show has been all about transparency today.
Yes.
So that's a really wonderful thing. Evan, any thoughts about TPP before we move on to our resource and tip of the week?
Not really, because in preparing for the show, I was reading about TCP/IP, so I'm just in a totally different conversation. So sorry about that.
Well, that might be impacted here as well, Evan, because watch out, so then we don't really know.
Got it.
All right. Well, in keeping with our transparency theme for the show, over in New York, I guess they have an initiative in place with law enforcement called Stop and Frisk, where without a warrant or necessarily probable cause even, although if I'm wrong on that, do correct me, definitely without a warrant, if officers can stop whomever they like and search them if they seem to be suspicious. So the Civil Liberties Union in New York is up in arms about this and has released an app, an iPhone app, that is the Stop and Frisk monitoring app that quickly allows you to, if a stop and frisk is happening in your vicinity, capture that video and audio and submit it to the Civil Liberties Union so that they have a database of these things and are able to keep tabs on the government's activities in this regard. This was written up at Mashable, and I think it's at least worth some comic relief to mention that after all the downloads of this app and the various videos that were submitted, only a couple of hundred actually dealt with and a stop and frisk kind of situation. Many of the other submissions were simply officers flipping off the people who were attempting to film them, or people just playing around with the app. So, it's not a perfect system, but if you are in the New York area and you feel like lending the CLU a hand, then check out its Stop and Frisk monitoring app. Evan, any comments on this one?
Oh, it's kind of funny that people were maligning the cops for, filming themselves flipping off the camera. But what about the cops' First Amendment rights to express their displeasure? The ACLU is mad that somebody was speaking out. Come on, what's wrong with this? So,
yes.
Yeah, nice app. It's good. More information, the better. Good thing.
Exactly. All about transparency. We've been so thrilled to have David Levine from Elon University School of Law with us here today. I have, as I mentioned at the top of the show, followed along with David on his show, Hearsay Culture, and recently was at a symposium with him at Chapman University School of Law, where he talked at length and at a very insightful level about the intersection of technology and the law. And our tip of the week is going to be your tip from that symposium, David, if you would, for the law professors who listen to our show. Can you tell them what they can do on Monday morning to help deal with the fact that technology has been changing perhaps faster than law school teaching has?
Well, thanks, Denise, and it was great to be there with you, and like I said, to be there in person. So the general challenge, and I know we're short on time, so I'll make this quick, right? The general challenge is, what can we do relatively quickly to address the changing legal market and the economy and make legal education, more responsive, to student needs. And so I had several suggestions. I mean, the first was literally to ironically to stop and pause and have a conversation candidly with your students about what it is that in fact we're doing, right? Stop and listen and think and discuss where we are and how we can work together to address it. More specifically, my comments were, in the context of teaching internet law and IP. I have my students blog, right? I have them write up short 500-word comments that they then present to class in order to let them get into an issue that they're interested in, but also have practice literally in dealing with clients who may not be terribly interested in these topics and not willing to spend an hour and a half, discussing them. And the point is this, again, from a learning perspective, on the teaching side, is to get them responsive to the fact that this is a very dynamic environment. Eric Goldman, who has been on your show regularly and who I consider a friend and mentor, we have talked about this from the standpoint of getting students to be able to make good business decisions in a dynamic environment. So on Monday, we can literally stop and ask our students to start, presenting the beginning of each class, right? An area that they think needs to be addressed right now. And on the service side, and this goes far afield from technology and the law, but it's relevant to it. I have a belief that, as educators, we have a responsibility to our students beyond the time that they graduate. And so having discussions with students through all the technologies that we have that relate directly to careers and talking to them about how we can help them with their careers and work them through it and maintaining those relationships past graduation would be helpful. So what you can do on Monday is open up your door to those discussions. The context of all of these comments, of course, was the fact that people are very busy, but I think there are 3 easy solutions that can be addressed. And I should add that Chapman Law Review did a great job, and I'm looking forward to publishing these remarks in an essay in one of their volumes later on.
Excellent. Thank you so much, David. And I know that a lot of folks who listen to our show are considering going to law school. So, what could be better? I know I would have loved to have had you as a professor. So I wouldn't be surprised if you get some applications coming into Elon University School of Law as a result of this show, because, I think anybody who's listened along with us today can tell how wonderful it would be to have you as a teacher in all of these subjects. So thank you so much for joining us and sharing your knowledge and wisdom with us here today.
Thank you, Denise. And again, I've been a huge fan of your show for the last several years. I've listened to it driving. I've listened to it sitting on the couch. Thank you so much for having me here. It's been an honor. And again, anyone that's interested in emailing me, it's dlevine3@elon.edu. But it's been a pleasure, and I look forward to coming back if the opportunity permits.
Wonderful chatting with you too. And Evan, how lucky are we? This has been a great show.
It has. It's been a lot of fun. And I really appreciate the perspectives you take on these issues, David, because, they're nominally they're issues we talk about a lot on the show, cybersecurity, trade secrets in particular, those 2 issues. But, your approach really has kind of taken, novel approach. The approach has been novel, bringing up new issues and new approaches and new ways to think about these things. So that's something that I have particularly enjoyed and am grateful for, that we've had the chance to talk about these things today. So really good time. Thank you.
Thank you for being an outlet for it. I think they're critically important. And I appreciate you taking the time out. I look forward to continuing the conversation.
And if you can't enroll in David's classes, you can follow along with his podcast, which is Hearsay Culture. It's a radio show at Stanford that they distribute after the fact as well. And also he's Hearsay Culture on Twitter. So go find him there. Thank you so much, David, for joining us today.
Thank you, Denise. And thanks, Evan. It's been a lot of fun.
All right, folks, we're going to wrap up this episode of This Week in Law, but do find us on Facebook and on Google Plus between the shows. Let us know what's on your mind, how you liked the shows, what you'd like us to talk about. We love finding those nuggets of things that are important and not being discussed as much as they should be, as David helped us do today. So send us your suggestions for those things. Evan is Evan at twit.tv. I'm Denise at twit.tv. You can find Evan. He's Internet Cases on Twitter. I'm D. Howell over there. Hit us up in any one of those ways. We'd love to hear from you. And we'd love to have you back on our next episode of This Week in Law. Thanks so much for joining us today.